me look at my little AM. And let me see, I'm supposed to call it to order. Have everyone mute their microphones, please. Only turn them on when you speak. And remember when you speak to announce your name so that it may be gathered and recorded. Alex, would you do the roll call and announce if there's a quorum?
Yes, ma'am. Scott Anderson,
Present.
Patrick Shaw,
Present.
Brian Mitchell,
Present.
Kevin Medlin, Jerry Matheny,
Present.
Greg Temez,
Present.
and Presiding Officer Pro Tem Sheila Sweat.
Present.
Okay, ma'am, you have a quorum.
Okay. Our next item on the agenda is open government training. Mr. Funderburg, would you like to address this?
Yes, Ms. Sweat, excuse me one moment. I'm going to share a document. It's a PowerPoint presentation developed by the department to help advisory boards with the nuances of the Open Meeting Act. I'm going to share that now. Hopefully you'll see advisory board open government training. Is that being displayed now?
It is, yes.
Thank
Does anyone not see it? Okay.
Well, thank you, Presiding Officer Sweat, board members. I'm Assistant General Counsel Christopher Funderburg. I'm going to go through the open government training the department is required to give to the board members every year. The training covers 3 statutes and each require transparency in government and public participation. These statutory mandates impact the function of each advisory board associated with TDLR, hence this presentation. The first statute we'll discuss is the Open Meetings Act. While it's important to be familiar with all 3 statutes and their purpose, the Open Meetings Act is the most relevant to your duties as the member of the Elevator Advisory Board. So that's the focus of our presentation, though all 3 are important. The second is the Administrative Procedures Act, also called the APA, and the third is the Public Information Act, also referred to as the Open Records Act. We'll start with the Open Meetings Act. We'll start with the Open Meetings Act in Chapter 551 of the Government Code. It requires meetings of government bodies be open to the public, and there has to be notice ahead of time to let the public know what the meeting will be about and where and when it will convene. The courts have held that the provisions that are in the Open Meetings Act are mandatory, and they're to be liberally construed in favor of this policy of open government. There are 3 key terms associated with the Open Meeting Act: quorum, deliberations, alternatively discussions, and meetings. We'll start with quorum. A quorum is a majority of the members of an advisory board as fixed by statute or rule. A quorum of a governmental body, including an advisory board or committee, must meet in order to take official action. Second, deliberation, or alternatively discussion, is the second key concept. Deliberation means a verbal or written exchange between a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. The third term, meeting, occurs anytime a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or at any time the body takes formal action. If the governing body takes formal action, which requires a quorum, or if the quorum engages in deliberation, either occurrence is classified as a meeting. Once that threshold is reached, the notice requirements of the OMA attach. Notice. The Act requires advance written notice of the date, time, place, and subject of each meeting held. TDLR provides this notice in the form of an agenda. Notice must be filed with the Texas Secretary of State at least 7 days before a meeting and must be posted online by both TDLR and the Secretary of State. A board or committee may not engage in discussion about a subject not included in the agenda. This is why the board cannot engage in back and forth deliberations with public commentators, as the subject matter of that discussion is a variable and could not be specified in the agenda. A follow-up question to notice, what about social functions, conventions, and workshops? If a board member engages in verbal or written exchange about an issue outside the jurisdiction of the governmental body, it is not a deliberation. Thus, the public doesn't have to be notified about the deliberation, and that deliberation doesn't have to have an agenda item. If 5 members of the board meet at the grocery store and discuss the price of eggs, this isn't a meeting that requires notifying the public. Or if during the meeting, the board deliberates on where everyone wants to go for lunch, the lunch discussion doesn't need to be an agenda item. Keeping in mind that a meeting occurs whenever a quorum of governmental body engages in discussion about an issue within the governmental body's jurisdiction. Can members ever meet in an informal setting without violating the OMA? Yes. Members are free to engage in conversation that is incidental to the event. However, the discussion will be subject to the Open Meetings Act if a quorum of members is involved and the members either engage in discussion or make decisions about a board or committee business or take formal action. Key points to remember. Always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. Do not engage in substantive conversations relating to board or committee, business, or policy when a quorum is involved and you're outside of an officially noticed and scheduled meeting. And third, beware the walking quorum. I'll discuss that a little bit further. A walking quorum, the formation of a quorum isn't limited to a specific time or location. Rather, quorums form through the communications between board members. These communications can easily occur outside of a formal board meeting, and the communications can stack up on top of each other, often without the board members realizing it. This reality creates the risk of the walking quorum. A walking quorum occurs when fewer than a quorum of members engage in discussion about official business, then communicate those discussions to other members. While fewer than a quorum of members participate, fewer than a quorum of members participate in the initial communication, subsequent communications with other members will result in a quorum discussing official business outside of a public meeting. I'll give an example. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have individually performed regarding the issue. One of the board members subsequently forwards the exchange to another member. The members have now engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed board meeting. Walking quorums can occur during conference calls, video conferences, hallway discussions, emails, texts, and other new technologies. The walking quorum concept, combined with newer technologies such as Twitter, Facebook, and instant messaging, raise new issues about meetings and compliance with the Open Meetings Act. The best practice is to avoid a walking quorum. Members should not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. They should not send emails or text messages to quorums of members regarding official business, even if each email is addressed and sent to each member individually. Should not create posts on social media about board business where a likelihood exists that a quorum of members could participate in the discussions, or ask a quorum of members, even on an individual basis, for feedback or commenting on board or committee business outside of the public meeting. This is also called polling, which is essentially conducting an informal vote on the issue. Guidelines for open sessions. A board or committee is limited to discussing the specific items on the agenda. During public comment portion of the meeting, members of the public are given an opportunity to speak, and the presiding officer may set reasonable limits on commenters. A member of the public or member of the board may raise a subject that has not been included in the agenda. However, any discussion of the subject must be limited to a proposal to place the subject on the agenda for a future meeting. Guidelines for open sessions. To avoid violating the act based on insufficient notice, members should limit discussions to the specific agenda item contained in the posting filed with the Secretary of State. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Not respond to or discuss issues that are raised during public comment, but which are not on the agenda. And specifically identify items for future agenda and communicate those items to TDLR staff. And now the stick of the Open Meetings Act. They're the penalties and remedies for Open Meeting Act's violations. Any interested person, including the media, may petition the courts to stop actions taken in violation of the Open Meeting Act. The Open Meeting Act also specifically states that an action taken in violation of the act is voidable. There are also criminal penalties associated with violations of the Open Meeting Act. Members who knowingly participate in a walking quorum or who knowingly participate in a meeting that is close to the public are subject to misdemeanor criminal penalties. The penalties are a fine of $100 to $500, confinement to county jail for 1 to 6 months, or both fine and jail. The best practice for the Open Meeting Act: avoid communications that involve a quorum of board or committee members about official business outside of a properly noticed public meeting. And during open meetings, confine discussion to items specifically posted on the agenda. And if this is a both broad and deep subject, here's some additional resources if you'd like to look into this matter and look into the issues raised by the Open Meeting Act further. Now I'd like to turn to the Administrative Practice Act. The purpose of the Texas Administrative Procedure Act, is to establish minimum standards of uniform practice and procedure for state agencies and provide for public participation and transparency during the rulemaking process. A rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law and policy, or describes the procedure and practice requirements of a state agency. A rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights and procedures. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. There are various sources for rulemaking. They can be necessitated by legislative changes, by request by the advisory board, internal discussion between TDR staff, the 4-year rule review required of all administrative rules, or by rule petition from interested parties. An interested person may submit a petition to a state agency requesting the adoption of a rule. An interested person is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. Here we have a flowchart demonstrating the process for the rulemaking process. It is both intensive and potentially lengthy, but this board, at the conclusion of this advisory board meeting, I'm going to ask the board to add to the agenda item a rulemaking work group so that we can actually get started on a rulemaking process for the elevator program. Again, this is the rulemaking rule review process flowchart, and some additional resources if you're interested to investigate, research this further. The Public Information Act. Public Information Act, or Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public, with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it was in connection with official agency business. The Act should be construed liberally in favor of granting requests for information. Request for public information. The public may request copies of public information, request to inspect the information in the offices of the governmental body. A request must be submitted in writing. A TDLR request must be submitted to the TDLR Record Center, which can be accessed through our website. There's tight timelines for responses to open records request. TDLR must respond to the request as soon as possible, but not later than 10 business days after receiving the request. We cannot ask why someone wants the records. We can only ask for clarification through the GC Open Records team. The general rule and common exceptions to disclosure. The general rule is a presumption of openness, but certain information is required to be redacted from open records. Examples include date of birth, most email addresses, driver's license, license plates, VIN records, credit card numbers, and any medical information protected by HIPAA or the Texas Medical Records Privacy Act. An Office of the Attorney General ruling must be sought to redact or withhold other information. If you, as a advisory board member, if you receive a written request for records or correspondence that looks like a public information request, please forward the request as soon as possible to the advisory board team, who will forward it to our open records team with the general counsel. If the GC Open Records team requests information from you as an advisory board member, please respond as soon as possible. The 10-day business deadline applies to all requests. And here's some additional information about the Public Information Act. That concludes my presentation. I'll stop sharing at this point.
I'm not sure if I can ask for questions or at this time about the Open Government Training Act and the Open Meeting Act. Is that allowable?
But since it's an agenda item and the public was on notice, yes, please.
Okay.
I'll answer as best I can, yes.
Thank you. Of course, I'm the one that's questioning here. Work groups, where do they fall in the midst of this open agenda meeting, because we have work groups
Mhm.
that apparently don't meet or talk or work on the group's initiatives. And I'm not sure if it's a communication issue or, I mean, I would like to have a 1 month vacation, but I'd just as soon not have it in prison. So, can you tell me that usually the groups are like 3 people and they're
Yes.
assigned by the TDLR. So can you tell me about how they would meet?
Well, and as you may remember, I think you were a board member assigned to the licensing work group that met a few weeks ago. Um, and the way that work groups are able to avoid having to go through the entire notification process required by the Opens Meeting Act, it's less than a quorum. So at that work group meeting, you were the only member present. But I think we can have up to 2 to 3 advisory board members present during a work group. As this is less than a quorum, no official action could be taken, and instead the discussion can remain internal. Then the results of the conversation that we have between advisory board members and members of TDLR staff are, then generate a report, and it'll be the results of the enforcement and licensing work groups that met these past couple weeks. I'll be presenting during the GC portion of this board meeting. But to answer your question, it's less than a quorum, and no official action is being taken. The discussions remain internal, and then if we want to take official action, those work group results are added to the advisory board noticed meeting, and then the board can decide whether they want to take action on them at a later date. But
Perfect.
basically, it's because less than a quorum.
Okay, so if the 3, I'm looking at it and it looks like there are 3 people in every work group. If all 3 of them were there, it would still not be a quorum, so it would not interfere with all of these other requirements that I would need a lawyer to hand in hand with me.
Correct. We are not trying to lead you into a trap for the unwary. Like
Thank you very
the work group procedure has been all the advisory boards engage in these work group discussions, and they comport with the requirements of the Open Meetings Act.
Perfect. Okay, and next on the agenda is the approval and tell me important. Okay, yes, it's approval of the minutes. We must now approve the minutes for the October 8th, 2024. Do any board members have any comments regarding those meetings? Did any board member read those minutes? No, you don't have to answer that part.
Greg Tomatoes, I move that we accept the minutes.
I
need a
second that motion.
Okay. The meetings have been seconded and so we may move forward with the meetings as presented.
Ms. Sweat?
Yes.
I'll be happy to take a roll call vote for that. But just to clarify, the motion was made by, was that Mr. Tamez?
Yes, correct.
Okay. I'm having difficulty hearing you, sir.
Yes, that's correct.
Okay. And it was seconded by,
Scott Anderson.
Scott Anderson. Thank you, sir. Okay. I'll proceed with the roll call. I'm sorry, with the roll vote. Scott Anderson,
Yes.
Patrick Shaw,
Yes.
Brian Mitchell,
Yes.
Jerry Matheny,
Yes.
Greg Tamez,
Yes.
and Presiding Officer Pro Tem Sheila Sweat.
Yes.
Okay, the motion has passed, ma'am.
Okay, perfect. Okay, it appears that the next information is the public comments. And there appears to have not been any emails sent for public comment.
That's correct, ma'am.
Okay, so we will go forward with staff reports. Miss, now you can see, I can't see. Miss Hoffman?
Yes, ma'am. Good morning.
Yes, can you present the staff report for licensing?
I sure can. Good morning, advisory board members. My name is Mary Hoffman, and I am the licensing manager for the Industrial Blazers team, which is where the elevator program is housed. I have been with the team since October of last year, and so I'm happy to meet you all today for the first time. And the licensing division staff report, you have that information and the statistics in your meeting materials for fiscal year 26, which started November 1st of 25. So we're in just, I believe it's about 1 month of numbers here for statistics. So you'll see the number of contractor licenses that have been issued and renewed. So issued is 4, licenses renewed is 18. The number of inspectors that have applied for a new license is 1, and licenses that have been renewed is 6. You'll see total populations for FY25 and FY26 also on the far right-hand columns. And for the total equipment that we have, you'll see those populations as well. And for new inspection reports processed, that's a total of 131 so far, and renewal inspection reports processed is 4,104. For current projects for the licensing division, TDLR, the licensing division, along with other division staff, are working on a project to develop a new licensing system. That new system is going to be called TDLR Core. And this new system is going to provide enhanced online services, some self-service options that will really bring a lot of these programs to, current ages. Currently, there are a lot of programs that cannot apply online or submit a payment online. And so with this new licensing system, it will bring a lot of enhancements and changes to benefit all of our licensees. You will have self-service options like logging into the portal, being able to update maybe an email address, a mailing address, or a phone number, as well as updating, uploading documents and completing forms online in the system. So as you know, TDLR regulates many programs. Right now it's 42 programs, I believe, with the new programs assigned to us during the last legislative session. And so this is going to be about a 3-year long project, and programs are going to go in or transition into the new licensing system in phases. And so the best way to keep in touch and involved in what's going on with when elevators are going into the new system is subscribing to email updates. And you can go to TDLR's main webpage, and on the top of the webpage, there's a little tab that says email updates, subscribe, select the elevator program, and anytime that there's an update or any outreach or anything that we need to provide to all of our licensees, we will send an update that way. Or you can always just come back and check the website. The website will be updated as we move through and giving you, an update and a heads up before the elevator program actually transitions in, and kind of giving you information on what to expect. I am available to answer any questions. That is my report.
course, I will be the only one that asks a question.
Of course.
Of course, that's right. Um,
No, I,
I do have a question. Submission of inspection reports.
Mhm.
I do a lot of, in many different states,
Okay.
and some of the submissions, um, are helpful, and some of the ways to submit are almost impossible. Will you have any, guidance from the inspection community, um, on what needs to, or what they wish to have in this new system?
I don't know that we can definitely take comments. We can also have meetings with the advisory board, maybe a work group, licensing work group, if there are certain things that are very important. However, with the new licensing system, there are certain things that the vendor is able to provide to us. And as part of this project, um, we do have a wish list of things that we would love to improve for the elevator program. And so I'm pretty sure that we have a lot of those ideas already in mind and in place to make those enhancements and improvements to that program. If you have anything specific, you're more than welcome to reach out to me and we can have a discussion, or you can send me an email so that I can kind of be that voice as well for you.
Okay, thank you.
You're welcome.
Mostly,
Sheila, I have this is Jerry. I have a question.
yes, sir.
I don't know if you're appropriate, but I'll ask you this question.
Okay.
In the last 12 months, how many renewals for elevator contractors have been denied?
I do not have that information. I don't believe that is a number that we report. However, I can get with our management analyst and see if that is a number that he can provide to us, and then I can get back to you on
The
that.
second question I'd like to have on that report is how many were denied and how many investigations were conducted on elevator contractors in the state of Texas in the last 12 months?
So this is contractors. The enforcement division will be providing a report in just a few minutes. I don't know if they'll cover any of that information in their report, but I can definitely get back to you on that information.
I'll ask them when they show up.
Okay,
Thank you.
you're welcome. Any
Okay.
additional questions?
Okay, then we go to the customer service division. I knew I should have practiced the names. Ms. Jazan, Mona Jazan.
Yes. Good morning.
I'm sorry. Could you say your name for me so I don't mispronounce it again?
You said it great.
Thank you. Sorry. Okay.
No worries. Good morning, advisory board members and TDLR staff. My name is Mona Jazan. I am the Director Executive Assistant, standing for Claudia Enriquez, who's the manager for this program. As you can see on your screen, our statistic reports show that we did have a decrease in our contacts for fiscal year 2026 in comparison to fiscal year 2025. That goes for emails and our phone calls. And other than those statistics, I'd be happy to take any questions.
Open it up to the board members for any questions. Perfect, then we may move on. The Enforcement Division, and I will call on Mr. Stuart Baggish.
Thank you. Good morning, board members. My name is Stuart Baggish. I'm a prosecutor with the Enforcement Division. I will present the Enforcement Division's report today, focusing on key statistics and case highlights involving ELE prosecution cases. The report begins with the division's performance measures You'll notice that 428 cases have opened this year compared with 574 cases last year. The next section in the criminal history review for applicants who may have disqualifying criminal history. As you see, 25 of the ELE applicants were reviewed for criminal history, of which none were denied or revoked based on their criminal history, just like last year. The next section details where the Enforcement Division's ELE complaints originated, whether from consumers or from within the department. 436 were from consumers as compared with 285 from TDLR. And then below that is a pie chart for you based on the number of cases opened from the complaints received just above. While the department as a whole has a near perfect Mercedes emblem for its pie chart, reflecting on the one hand equal shares of departmental versus consumer versus criminal history points of origin, the ELE program specifically looks different, depicting 2/3 being from TDLR itself and only about 1/3 being from consumers. In the orders issued section, which is down just a little bit, we did have 60 total orders this year, of which 58 were agreed orders, 1 was a default order, and 1 was a vacated order. In the section entitled Cases Closed Without Disciplinary Action, it shows that we issued 188 warning letters and closed 48 other cases for insufficient evidence. Both of these are less than last year. In the section entitled Violations Resulting in Disciplinary Action, you can see that there are 57 failures to inspect equipment annually, 3 cases for not filing an inspection report and/or fees within 30 or 60 days, 1 case for refusal or interference with inspection or investigation, and 1 case for either no or incomplete maintenance or inspection records or MCPs. 2 cases are described in the case highlights, where we provide summaries for you to read at your convenience. That concludes my report. I'm available to answer any questions you may have.
And I'll open this up to the board. Jerry, would this fall into your question before?
I have no idea, Sheila. I don't know. I
I
don't
think-
know.
I'm sorry. I think the easiest way to get through this, it's a longer report than the other ones. If you look at the investigations, the source of the complaints, it indicates on page 1 of the report, complaints received by source, and that indicates consumer complaints, shows that there were 436 that were received, and then the ones that were opened under caseloads in enforcement, you can see the number that were opened was 428. The number of complaints that were closed. Those cases came to enforcement by way of investigations. We don't have a number that simply indicates the gross number that has been reported by virtue that investigations has opened up, because I don't believe that is a number that is tracked.
Okay, does anyone else have any questions on this custom
Yes,
enforcement division?
this is Scott Anderson. I'm still a little confused. What's the difference between ELE and TDLR I mean, is that for the entire department, and then the ELE is just for the elevator elevator escalator division?
Yes, the TDLR pie chart shows the entire department and all of the programs that it handles. The ELE pie chart shows only the ELE program within TDLR, and there's 34% of the ELE complaints are consumer complaints, and 284 are departmental complaints, which includes complaints from inspections, investigations, internal departmental sources, as opposed to being members of the general public.
Well, this this may rank. So are these consumer complaints? Are consumer complaints almost entirely related to injuries, or where do these complaints come from?
They come from members of the general public. I can get you information on the number of complaints, but as far as the quality of each complaint, I don't believe any generalization can be made about it. A complaint may come in from a consumer who had to wait because one of the elevators wasn't in service at the apartment building they lived in. It
Okay,
can
so
be very minor
so
things that can
I'm still
trigger a
just
complaint.
I'm just trying to get a feel for injuries and where that's going to come up, and that'll maybe be in another report. I feel like
That
Jerry, maybe I just need to keep my mouth shut and keep waiting.
detail of that nature is not currently a category that is classified on the report that the Enforcement Division produces.
Mr. Bagish, it doesn't appear to me that any of this report is related to contractor investigations. Is that correct?
Well, the investigations are a source of the departmental complaints. That is what is represented in the report. As far as complaints specifically against contractors, that's currently not broken out in the format of the report that we generate.
So I will ask you this question. Are you aware of any contractor in the state of Texas that has lost their license due to an investigation in the last 24 months?
Not me personally, no. I've only been appointed to the building and mechanical program since September 1st. That's something I'm happy to look into for you.
So I'm going to make a comment about that. And I don't know if people are taking notes or they're interested in my comment, but I was told by someone at TDLR during the conversation about a violation that I was aware of, that I am the only person, the only contractor in the state of Texas that calls TDLR when I see serious violations. And I don't know why that is. I'm not going to try to figure out why that is. I'm going to continue to do it until somebody does something about it. That's my comment.
Okay, I'll keep my mouth shut. As an inspector, or any inspector, should report violations of anything that is in our code, period. So if it's going to the wrong people, we need to have that addressed. Now I have to find where I'm at again.
This is Scott Anderson. I need to jump back in here.
Yes, sir.
We are not tracking accidents on elevators and escalators. I mean, I've been on this board for 15 years, and I know it's been a long time since a meeting, but we always had detailed information as far as, incidents, accidents, whether they were elevator or escalator. And I think that's something we should be able to see.
I have some input on that for you, Scott. So it's up to the owner of that elevator to file a report with TDLR when an accident occurs. That's how it starts. And I don't know where it goes after that. But if they do not file a report, Scott, nothing ever happens.
The compliance division, sorry, this is Mary TDLR, Mary Hoffman. The compliance division will be providing a report that I believe includes information on reported incidents. So that information may just be a couple of presentations away.
Okay, thank you very much.
You're welcome.
Hello, Patrick Shaw here. To kind of piggyback off of what Mr. Matheny was saying, I currently do perform inspections, and I have signed a paperwork and submitted it to TDLR of an incident, not a major one. Somebody got in and with a vacuum, and it was attached to the outside plug. She kind of got hurt. Sent that into TDLR. Haven't had any follow-up information. I did check in with Edmund and let him know. He mentioned to just kind of go back through the elevator to make sure any doors or interlocks or everything's all working properly, and then we could return it back to service. Thank you.
Yes, and hopefully at the end, when we have, I think there's a place where we can have recommendations for agenda items. I'm hoping we can also get some work groups involved, and both of those are very important to me. The state of Florida has thousands of things reported to them, and as far as I can tell, we don't report or collect, and we need to have communication defined in that regard.
Ms. Sweat,
Yes,
and
sir.
board members, that section will be coming up on the agenda, on agenda item I for the recommendations. So
Yes.
we do have that on the agenda.
Yes, it's in pink on mine. Yes, sir.
Oh.
Okay. Dadgum, where did I leave? Enforcement Division. Next, for Education Examination Division, and that is Ms. Cortez.
Good morning, advisory board members. Gonna wait just a second for us to get the presentation back up. Thank you, Alex. All right. Good morning, advisory board members. My name is Simone Cortez, and I'm a program specialist 3 on our exams team. I'll be presenting today's staff report for the Education Examination Division. Shown here, we have our continuing education course approvals that include the total courses available now, as well as our newly approved courses for fiscal year 2025, actually. And I apologize because the chart for 2023 is actually a typo. It should say 2025. And then we also have for our newly started fiscal year 2026. And I'm available if you have any questions.
Again, the new one that's come in, who is that? What is that new course?
So that was just a course that was approved. I don't know exactly which provider that who submitted the course application.
Okay. Okay. Any questions?
I got a comment about that.
Thank you.
I've held my QEI for a long time. I'm not going to talk about how old I am, and I appreciate everybody listening to me. But it seems that there's a requirement in the state of Texas, and they don't provide anything for that requirement. And if I'm wrong, you tell me this. But in order for me to keep my responsible party, which is required for an elevator company to have a responsible party, I have to go take a course somewhere, and the state of Texas only approve courses. They don't provide those courses. And I find that very odd that you would have a requirement and not provide that service. I just want to make that comment.
Thank you for your comment. Yes, this is a common theme throughout most of our programs where we require continuing education, but we do not actually provide the continuing education ourselves. However, the department does review, and I believe for elevators, compliance assists us with reviewing the course before it is approved. So the department does approve aspects of the course before allowing it to go out to for our licensees.
Hello, Patrick Shaw here. Um, I'm on the QEITF certification board, and if TDLR wants to have somebody come down and set a training schedule so that people here or in Dallas or wherever in the state, they can come down and train, and then that way it's an approved directly from you guys at TDLR. Thank you.
Thank you for that, Mr. Shaw. Can you restate the name of that organization so I can pass that along to my manager?
Yes, it's Qualified Elevator Inspection Training Fund.
Okay, thank you very much.
Thank you.
Okay, does anyone else have any questions about it? Because I too am one of those whatevers. And I strongly feel like I get it from committee work on committees for the code and that kind of thing, because yes, there's nothing specific for Texas. So that might be something we need to address. And the next one I have is Compliance Division. Okay, Edmund, are you here? Are we here? There we go. It's all for you. I'm not hearing anything spoken. Do you have your mic off, sir?
There's a technical issue on this end. We're working on it. Edmund should be on the line in just a second.
Sure, no problem.
Hello,
Yes, sir.
my name is Edmund. Chief Elevator Inspector, State Texas. Law, elevators, escalators, and related equipment. We have changed our organization structure and our staff.
Sheila, that's not working for me.
Marshall is our deputy chief.
Yes, sir. Mr. Valasana, we can't hear. You're very, very staticky.
Sheila, he's in Texas. I'm in Europe. I'm doing well.
You are doing good.
Hello, can you hear me now?
Much better. Yes, sir. Please continue.
Okay. Hello, my name is Edmund Villasana. I'm the Chief Elevator Inspector for the state of Texas. I oversee elevators, escalators, and related equipment. We have made some organizational changes with our staff. The Deputy Elevator Chief Inspector has moved to the Office of Strategic Communications, and we have added an additional project specialist. The purpose of this was to make our system more efficient and cross-training our personnel so they're able to provide processes in case there's a situation where another individual is not available. That specialist is Roy Melton. And the next thing is that we have on our regarding our statistics, all of our statistics have increased except for waivers. This is partly because of the we have created a mandatory inspectors seminar, and part of the requirements we have indicated are to notify us of any issues regarding elevators, escalators, or related equipment where an incident occurs or an accident occurs. And this has increased the notification to us regarding these situations. Our current projects that we have ongoing are the overdue inspection reports, and we are meeting on a weekly basis to reduce this amount. The next thing is that we have been continuing with our project of the mandatory inspectors seminar to make sure that everybody is up to date with all the changes, all the procedures, all the processes, and how we function. The second thing is that we have been we have revised some of our forms, accident forms, so we can be more specific about what has occurred and whether the incident is an issue that occurred, but there was no need for a follow-up investigation. Accidents that have occurred where there's been an injury or there's been a question about whether the elevator, escalator was functioning properly. We notify the customer to have their elevator contractor and an elevator inspector of their choice to do a full annual investigation and testing all the safety circuits and verifying that everything is functioning properly before the unit can be returned to service. We are looking into the instruction of updating our elevator contractors and owners or owners representatives to make sure they're aware of the changes that are occurring, and make sure that they are aware that they need to notify us of any incidents or accidents that occur. This is going to be coming out in the next few weeks, and hopefully this will resolve some of the issues that have occurred in the past. The outreach program that we have right now, we are currently we're currently scheduled to have a seminar in Pasadena for all the fire chiefs, fire marshals, and that will occur, I think, on November the 20th. And I think it's going to involve approximately 125 fire marshals across the state of Texas, and it'll be at the Pasadena Convention Center on November the 19th and the 20th. This will conclude my portion of this meeting. If you have any questions, please do not hesitate to contact me. Thank you.
Okay, I'd like to open this up to the board for any questions. Please don't let me
I-
be the only one that asks.
I'm
Okay.
gonna start, Sheila. I wrote down several. Edmund is Jerry Matheny. How are you, by the way?
I can't hear him.
Can you hear me, Sheila?
I can hear you.
Okay. Is somebody sitting next to, can you hear me, Edmund?
Yes, now I can.
Scott had asked about accidents and incidents, and you and I had a conversation recently about the difference between an incident and an accident. Can you scroll back up to the top of your form there where you show how many accidents happened so far in 2025, please?
Yes,
So you've had 0 elevator accidents in the entire state of Texas in 2025?
we had one accident that was reported.
You've
to
had
us.
one in 2025. One
One
reported.
reported. That, and see, that's been the issue in the past, is sometimes
Yep.
these accidents are not
You
reported.
see the issue there, Scott? That's why you're not getting any. Number 2, can you tell me what an incident is? And when you and I talked, we talked about that being an entrapment. Is that still on the list of incidents?
Yes, it is, because sometimes the entrapment involves a piece of equipment that has malfunctioned, and before we turn that unit back into service, we want to have verification that there is not a problem with the equipment. In the past, the elevator contractor will come in, find the issue, resolve it, and return it to service. However, the incident occurs again, or the entrapment occurs again. So that's why we wanted to verify that the equipment has been tested not only by the elevator contractor, but witnessed by an inspector to verify it's functioning properly.
So in the entire state of Texas, in 2025, you've had 19 incidents and 0 accidents for 43,000 elevators.
You know, we've had one accident, and we've had in fiscal year 2024, we've had 11, and in fiscal year
That's
25,
escalators.
I'm sorry, elevators is going to be
0.
0, and the incidents were 10, and the fiscal year 25 was 19, where they've
Reported.
almost doubled.
Reported.
Yes, reported, and
Okay.
that's why we're having the updates to
So I
notify
want to go back and
everybody.
ask a couple of questions. Since you are the head inspector for the state of Texas, Edmund, I'm not holding you, I'm not putting you in a spot, but I'm an elevator guy. You know, I'm an elevator guy. So I got a couple of questions based on what you've been talking about. And I've got them written down. How many elevators has the lead inspector actually inspected in the state of Texas in the last 12 months?
The lead being myself,
Yes, sir.
I normally don't do the inspections myself. I have someone to go inspect the equipment, and then they report back to me prior to doing the investigation and after they've completed the investigation. When I go
Okay.
out to a location, it's to investigate what has occurred and to determine if the inspections were done properly.
How many how many people do you have in your organization now?
In our staff, we have 5.
How many of those people have previous elevator experience?
3.
How many of those people hold a QEI?
Myself.
So who are you sending out to do the investigation before you go out there, Edmund?
The investigators go out first to find out who the customer is, who the contact person is, who the elevator contractor is, what type of incident occurred, whether it was something minor or whether it was where it occurred, an injury occurred. That's why they contact me before they start their inspection, and then once they've completed it, they contact me again, so I know whether I need to go out and look at the equipment also, because there's something that's in question about what occurred. For example, the inspector went to look at a escalator at a location, And on his arrival, he found that there were some items that were not in compliance. And once he explained that situation to me, then our deputy chief inspector and myself went out and investigated ourselves to verify everything that was indicated to us. And
Edmund, is the investigator a elevator industry professional with a QEI license?
they, in their department, I don't know what their qualifications are, except
I'm
that
gonna
they
take
go
that
out
as
and
a no.
investigate.
I'll take that as a no. I'm sorry, guys, but I was at the last meeting. I was at the last meeting. Edmund had 5 people. That is not improved. It's not improved by the number of elevator professionals, history in his division, and nobody has experience except Edmund. And he doesn't go out and investigate first. He sends out an investigator that has no elevator knowledge. I got to tell you guys something, and I'm gonna mention this one time and this one time only. Everybody knows about this. Everybody knows that there is no ramifications for anything that occurs in the state of Texas, no matter what, unless somebody loses their life. And usually the contractor is I don't know what happens. I really don't know. Edmund, I'm not beating up on you. I'm just beating up on the process. You don't have a big enough. I have 5 people in my office, just admin, that run a company, have about 1,200 elevators on service. You have 43,000 in the state of Texas. It is incapable for you to manage the state of Texas with 5 people and only one having an elevator experience. I have one more question. Is it still true that people with responsible party do not have to work for the elevator that they list as a responsible party for that elevator contractor?
They have to have the experience, the 2 years of experience in the elevator industry, but not necessarily for that particular company.
So a personal with responsible party does not have to work for the elevator company that they are the responsible party.
Oh, I'm sorry, I misunderstood what you were asking. It's
There
just
are people, there are people in Texas that have responsible party status that have it listed for more than one elevator company. Is that correct?
I believe so, yes.
How could that possibly be what was intended? A responsible party would be a person, from my understanding, that would be part of that organization to lead them as a responsible party.
It's my understanding that when they apply for their application, that's where they have to show as a responsible party working for that organization. Or however, if they leave that organization, then that responsible party would not apply. They would have to reapply if they're working for another organization.
But there are more than there are responsible party people out there. Like I have responsible party, but it happens to be for the company that I work for and that I own. But there are responsible parties out there that neither own an elevator company nor work there. Is that the intent of TDLR?
I'm going to have to research that. I can't give you an answer without
Because that's what's happening,
verifying.
Edmund. That's what's occurring. Is
Yes,
that right, Sheila?
that is very much occurring, and a lot are selling their responsible party requirements to those companies. You pay me this, I'll be your responsible party.
So, Sheila, I don't have your agenda in front of me, and I'm sorry, but are we going to get to TDLR inspections, or is this something we need to talk to Edmund about right now?
We're getting to work groups, rules, no, nothing specific for inspections.
Can I talk about it?
Yes, sir, if I get to choose, you may talk about it.
Thank you. So, Edmund, you and I have bounced this around a lot, and I just need to have some progress made here. And I have a question here, but my question is, if we're not requiring
Excuse me,
the-
I'm sorry if, to interrupt, but, I believe that it's not on the agenda.
See, I
and so
didn't
we would
have
need
that
to stick
authority.
to the
That's
agenda. I
convenient. That's
apologize.
convenient. No, that's convenient.
I
So is
have
there
that under
somewhere,
new.
Alex, I can talk about this?
I apologize. I had to give my, this is Chris Sunderberg, General Counsel. I had to give my microphone over to Edmund. I don't, can you hear me?
I can hear,
Okay,
but I can't
good.
see. Oh, yes, sir. I can
Oh,
see
okay.
you.
Okay. So your question is regarding inspectors, or rather whether we can discuss the inspections process. We have an agenda item where licensing work groups talks about the, I guess, the dearth of inspectors in Texas and, potential solutions for that. That may be where this discussion would more organically arise. I don't know if we can discuss this as part of Edmund's compliance report.
I'm sorry, I
That's,
was talking about elevator inspection reports, which is a compliance for TDLR. They have to have their elevator inspected every year. I would certainly think that falls under compliance.
Excuse me, one moment, let me consult.
I should have brought my attorney.
mine broke his back last week. He's upstairs. So that's my son.
That's what you get for being in Europe.
They're probably cheaper there.
Christopher, you're muted. There you go.
After discussion, I believe, I think just in the interest of making sure that the public is aware of what we would be discussing and when, the inspection discussion that the board member would like to have is best suited for agenda item F, discussion of work group meetings and tasks.
Let me
Yes.
know when I can talk about it, Sheila, would you please?
Yes, sir. I
Yes.
will. I have it on
Appreciate
here.
you. Thank you.
Is there any more questions about the agenda update? Because I have one. The Pasadena group of firefighters in November, which is this month, who is going to be talking to the Pasadena fire chiefs or the fire chiefs in Texas that are meeting in Pasadena?
I will be talking to them.
And one of the most difficult parts of our code is about firefighters and their recall and their availability and what they know to do and what they can do and that whole situation. So is that in the educational portion that they have asked for?
Yes, it is. I'm going to go over the smoke detectors, heat detectors, sprinklers, rescue operations, what the things that they can do and the things that they shouldn't do because of safety issues. Specifically, when you have an entrapment and the fire department is called in to remove the passenger, there's no assurance that that elevator is not going to move. If there's a brake failure, that elevator could move at any time. And if the firemen are in harm's way, it could cause them injury. The second thing is that even though a main line is locked out and tagged out and there's no power to the elevator unit, there's stored energy in the drives that can cause an electrical shock if they happen to be close to the equipment or they put their hands in the wrong place. So in those situations, even though they're following their procedures, they may not be aware that the elevator could move while they're trying to remove somebody from an elevator. So those will be covered in our presentation.
Okay, I might join that. I might join that group because Number one, I was asked to, but if I can get November 20th, where I'm in Pasadena. Yes, sir. Any other questions regarding the agency update?
Yeah, this is Scott Anderson again. And this is just a general question, probably for Edmund, because it's been so long since we've all gotten together. Are City of Houston and Beaumont still exempt from the TDLR? Are they still self-regulating, those two entities?
The city of Houston has their own jurisdiction over their area. However, they still have to meet the requirements of the A17.1 2016 code requirements.
No, that's fine. I just want to make sure, see if Houston was still separate.
Yes,
And still federal buildings are separate on their own also?
federal owned buildings or federally leased buildings
Okay.
are exempt.
Are there any other municipalities in Texas who are on their own?
There are ordinances in Carrollton and Addison that their requirements are more stringent than the state of Texas. So
Okay,
when the
that's
fire
fine.
marshals go over there, they follow their procedures.
I'm just trying to get a feel for what areas we're not hearing from when we talk about TDLR. So that's all I have. Thank you.
And I apologize.
That's a good question. Sheila, that's a good question. If Houston has an incident, are they required to inform TDLR?
I would say no. They are probably only required to inform their AHJ, which they have one. I'll ask them. And I'm sorry, the agency update is next, and that is with Susanna Holt. And I apologize that I got those mixed up. Susanna?
No problem. Yes, good morning, Chair. Good morning, advisory board members. I'm Susanna Catrone. I'm the Chief of Staff for TDLR. I wanted to bring to y'all's attention a couple of things specific to your program, which you are likely aware of. But during the 89th legislative session, there was a cleanup bill, House Bill 3848, filed by Ana Hernandez, that modernized the process for submitting inspection reports and paying fees related to the inspection of elevators and equipment, and allowing for this to be done online as opposed to the submission of paper forms. I know that Ms. Hoffman mentioned the TDLR Core project, which is our new licensing replacement project, which is underway. It is a 3-year project combining 7 legacy systems into one, but will provide the industry as well as our other regulated programs with greater efficiencies. This agency update is also, the purpose of it is to provide you all with some bigger picture TDLR status updates. And as of September 1 of 2025, we now serve over 1 million licensees in the state of Texas. In FY25, the agency fielded more than 12,000 consumer complaints. I believe that Mr. Bagish highlighted that on the enforcement report, conducted more than 7,000 investigations, and received over $800,000 in restitution for consumers. The 89th legislative session also brought TDLR 2 new significant programs, and we have almost doubled our staff in that we now have the lottery and charitable bingo. They are now administered by TDLR, and there is a dedicated transition team incorporating those into the agency. You all are also, back to the reason that you're here, elevators, you're also likely aware of the media coverage of the issues in Missouri City related to the senior living facility. In June of this year, the Enforcement Division did assess a $381,000 administrative penalty against the owners of the senior living complex, where residents had reportedly been stranded for 2 months. Enforcement actions of this scale are not issued lightly, but when the health and safety of seniors are at risk, we act in exigent circumstances, and we received reports of seniors missing their doctor's appointments, unable to get up and down the elevator to go to the grocery store and take care of basic necessities. Currently, both of the elevators at the facility are repaired and are in compliance with TDLR rules. Our enforcement division is in negotiations with the respondent to ensure continued compliance and to resolve that pending enforcement action. So I did want to mention that in this portion of the report. Thank you all for your service and your attendance today.
Thank you. Is there any questions or discussion about the agency update?
Yes.
Yes.
I'm not aware of Missouri City, and it's an unfortunate situation. But what I'd like to know was if you know this, and if you don't, I'm fine with that. But did this facility have a maintenance contract in place during all of this investigation?
Again,
Excuse me, is this an ongoing?
Okay.
enforcement action?
They had 3 contractors. Otis Elevator was their first contractor. They had a warranty period. When it expired, they backed away from the contract.
Excuse me.
They called in a second elevator contractor.
Edmund.
Their recommend.
Chris Funderburg, General Counsel. I'm sorry,
Oh.
Edmund, is this an ongoing investigation with enforcement?
No.
It's been fully resolved. Okay. Thank you. I just wanted to make sure of that.
Okay.
Just so you know, Christopher, I didn't bring it up. They did.
Yeah. Thank you, sir.
One thing, if I can bring up real quick, if I could have all the board members to please keep their video on, please. Thank you.
The second contractor that came in recommended that they get Otis back in because the equipment was a type that they weren't familiar with, and they didn't feel like they would be able to correct the issues on those 2 units at that location. The third elevator contractor was Elevator Service of Beaumont. They came in, they located all of the issues and corrected the problems on both elevators. And by the way, the original issue that occurred was a low power voltages coming into the machine room. The power coming into the building for the elevator system, instead of having the 480, it was down below 100 volts. And this was causing damage to the drives and some of the drive components. They had a difficulty getting these new components from Otis Elevator. There was a long period of not being able to have that equipment shipped out to the jobs. But once they had all the materials on site, all the components, all the drive, then they were able to get both units in service. And there was an additional location that they were able to get both of those units in service. But they continued to monitor to make sure that the equipment didn't fail again after they completed all their work. And to this date, the elevators are still running.
Okay.
Yeah, I guess the reason I brought this up, Sheila, is I think that TDLR appears to me to hammer the elevator owner instead of the performance of the elevator company. And the last time I checked, elevator owners don't work on their own elevators. So I think somehow or another, we're going to have to pull those things together. I appreciate everybody listening to me, but there is some issues with the contractor that's licensed to work on these elevators, and they were contracted to do that. And I hope that they have some litigation against the contractors for that, because there is some liability there, but that's just my opinion.
Okay. Understood. Um, and I would make mention that if these appear to be new elevators, I'm wondering who inspected the original installation and how on God's green earth it moved with 100 volts.
Ms. Sweat, I've just been advised by our enforcement division
Okay.
that the case is not discussed.
It's still, yes, it's still under investigation. Got it.
Thank you.
Well, we'll move on to the explanation. Oh, the discussion of work group meeting reports and tasks. And Mr. Funderburg, that is your,
Yes, thank you, Ms. Sweat. Or,
there you are.
I'm Chris Funderburg, also Assistant General Counsel with the TDLR's Office of General Counsel. Just as a little backstory, in October of last year, I was the department's Attorney General assigned to the elevators program. While I was assigned to this program, the advisory board met on October 7th, 2024. During this meeting, the advisory board agreed to assign several board members to work groups to discuss issues related to elevators and escalators with designated representatives of the department's division, compliance, licensing, enforcement, general counsel. These work group topics included elevator plan reviews, inspector and education requirements, and licensing for elevator technicians. In December 2024, the department began preliminary efforts to schedule these work group meetings in advance of this current advisory board meeting. Then in February 2025, the elevator program was reassigned to a different attorney general. Finally, in September 2025, the elevator program was reassigned back to me. So while it appears that I just wanted to let you know there was a break in continuity on the Office of General Counsels, but given the short turnaround time between my reassignment and this meeting, I'd like to believe the department has made good progress addressing some of the concerns raised by the board during our last meeting, as well as developing a roadmap for the future. First, two of the work groups I mentioned met in October of 25, and I believe the resulting discussions were productive. First, our licensing division met on October 22nd to discuss elevator inspection education requirements, licensing for elevator technicians, and also proposed amendments to the existing administrative rules governing elevators. The work group reviewed a revised inspection report developed by Compliance Division to address issues associated with reportable conditions and repeated violations. This revised form allows building owners to notify the department if any violations that already reported have been corrected. The revised form also gathers additional information for building owners on whether any reportable conditions have existed for more than 60 days. If so, the building owner must notify the department of the dates by which the correction will be completed. Finally, the revised forms require the building owner to specify whether they are applying for a waiver or a delay, and if so, whether the application has been submitted with the revised form. The work group has also reviewed and discussed proposed amendments to the existing administrative rules governing the elevator program. These changes proposed by the department will be finalized into rulemaking action for review by the entire board at the next advisory board meeting. And Ms. Sweat was the elevator advisory board board member who attended this licensing division work group. The second work group that met was related to our enforcement division. The first topic was discussion was the development of department strategies to increase the pool of available inspectors in Texas. The work group met to discuss the challenges faced by licensed elevator inspectors due to a substantial increase in elevator and escalator installations that accompanies Texas's explosive growth and the concomitant increase in the need for inspections and maintenance. The group that agreed that the problem is complicated, but that one solution may be to ease the transition from the career path of an elevator technician to that of an elevator inspector. For example, if during their career as an elevator technician, an applicant for an elevator inspector's license acquired sufficient education and experience in elevator, escalator installation and maintenance, then the solution may be to allow the department to accept this experience instead of other licensing requirements. implementing this dovetail solution will likely require a statutory change. Thus, the department has added the work group suggestion to our legislative strategic planning document for the 2027 legislative session. And second, I think the other major item that I'd like to report is that during 2025, our compliance division worked steadily on a series of amendments to the administrative rules governing this profession. I'm glad to report the resulting work product is ready for consideration by a rules work group appointed by this advisory board. After meeting and incorporating any feedback or suggestions from this rules work group, TDLR will be ready to begin the rulemaking process. The entire advisory board's participation will be crucial during this process and will in fact require the board to meet and consider these proposed rule amendments 2 times, with the meetings both relatively close to each other. When I say relatively close, 3 to 4 months. Thus, this board will be fairly busy for the next year or so, which I hope will be generally encourage a productive dialogue between TDLR and the elevator profession, in addition to hopefully leading to the enactment of substantial, well-designed amendments of the existing administrative rules. There's multiple important items of discussion that this board has brought up during the course of this advisory board meeting. All of them are relevant to the work groups that the chair can appoint to meet in between but this board meeting and the next one and the one after that. So I would suggest that I realize there have been a variety of concerns that we triage and then assign them to the work groups during the item recommendations for agenda items for the next board meeting. The department will make every effort to ensure that these work group meetings are scheduled in a manner that can allow attendance by all invitees, and that the discussions will then be compiled into a report and presented to the advisory board at the next meeting for its consideration possible action.
Please tell me I'm not the only one that wants to say something here.
No, please do. It sounds like people have some feelings. That's what we're here for.
Yes. We have woefully inadequate communication. Woefully inadequate. I'm on 2 of these 3 boards, and we have really not had any communication. And then we get this thing that we can't talk to each other, and that's what I mentioned before. And I had sent Mr. Jerry Matheny a note about this particular meeting because
Matheny's, Sheila, Matheny.
Oh, Matheny. Well, see, I only know you by Jerry. Sorry.
All right.
And so I'll just say I'm not Sheila Sweet.
Oh,
If you know me,
my God.
you would never know
No.
think that I was Sheila Sweet. I was Sheila Sweat, and that is
I-
correct. You spelled it correctly.
I apologize.
No, don't apologize. No problem. And I'm on 2 of these committees, and I was able to talk like the October 22nd, which was my birthday, when I was walking through the school of where we were inspecting elevators. And so it did not feel like it was something very official. And we need definitely more work group involvements, and we need some type of people on there that their responsibility is to make sure all of the people are involved. Again, Jerry, did you know anything about any of these other? I didn't think so. I'm not the only one that gets ignored.
No. And just so you know, Sheila, I'm
Yes.
100% available 100% of the time. I'm literally in Europe right now, and it is 6:30.
In the
And I'm
morning?
on a call. Huh? No.
In the morning?
No, in the afternoon.
Oh, in the
And
afternoon.
listen, I think the driving force for me, who anybody will listen, I've been in this industry for 43 years. And the
Me
most
too.
important thing to me is safety.
Yes, sir.
And I haven't heard anybody talking about safety today. And that's what inspections are all about. That's my statement.
Yes, sir. And like I said, we've got to get communication down. We've got to talk about safety, and safety is involved in every single solitary one of these work groups and why we should have these work groups. I am And also, I'm mega worried about the core thing, that they're adding things on there that are going to funnel in a way that makes things more difficult. I've been through a lot of states, and without a little bit of information and history of what things can happen when you change these things, you're going to inevitably be the one that funnels the information into a worse space. I have states that only allow me to use their words, and their words are not code words, whenever I put in a issue on their reports. So as an inspector, I am not able to do the violation. I'm not able to put into words the violation that has occurred, and therefore I'm having to use violations that don't even, that might come close. The problem is, as an inspector and as a consultant, I need to use my words, because when my name is on the bottom, it needs to be from me. And I don't want that to happen to Texas. That's pretty much all I got to say. Anybody else have any questions about?
I have a question about that. If I guess I want to talk to Susanna. Maybe she's the one that should brought this up. Thank you very much for being here. But if they're going to change a process, I'm going to call it a process. Are they engaging with professionals in the industry? Or are we just kind of doing this without engaging people on how it might work for us out there in the real world?
Are you referring to the rulemaking process?
That also.
Chris Funderburg, I believe he's referring to the core licensing system.
Oh,
Yeah.
yes, you
Yeah.
raised that question earlier in the meeting. I think that your input as a stakeholder and as an expert in the program is certainly welcome, and I will be happy to have someone working on that particular program area with the core development reach out to you.
Thank you.
Perfect. Now we get into, I think, explanation of elevator incidents and accidents. That is number G on the agenda. But I have no one to ask about that. I have no human being to point to.
It's got to be Edmund.
Okay, Edmund, talk to us about incidents and accidents, an explanation.
In the time that I have been in this position, there has been increase in incidents and accidents. So because of that, we developed this mandatory inspectors seminar that all the inspectors were required to attend, so they understand the procedures, the processes, any updates to the way they perform or witness their inspections. Trying to get everybody on the same page that they all have to follow the A17.2 guidelines with the latest edition in mind. When we did that, it seemed like overnight we started getting more notifications of incidents that occurred. Some minor, some could have become more severe. So what we do is when we get an incident report submitted, I contact the customer to find out more information. But in that process, I explained that our investigative portion has to answer several questions for me: who the elevator contractor is, the location, who was the person involved, was there just they slipped when they stepped on the escalator, or did they actually fall down the steps and sustain some injuries? So these incidents that have turned into accidents, we're asking the customers, the elevator contractor and the owners to let us know within 24 hours and let us be able to determine whether we need to have the inspector of their choice to go out and meet with the elevator contractor and perform these tests. And that's why I was mentioning earlier that the inspectors to notify me before he starts a test, because sometimes the customer will submit video of the incident so I can see better what occurred at the time. And that way I can discuss this with the elevator inspector before he starts his inspection. Once he has completed his inspection, he's required to call me again and let me know what he found. And that way I can determine whether that part of the investigation is concluded or whether I need to follow up myself and go to the location and look at some items that were in question. Once that has all occurred, then they can return that unit to service. We have had many elevator contractors that respond to an incident or an accident and they don't report it. And then several months later, we get a notification from the fire department that they've had several entrapments that they've had to respond to. And so then we're just finding out that there was an incident involving an elevator or escalator. And so that's why we are trying to push very hard to have the elevator contractor or owner's representative to let us know within 24 hours so we can process this situation and try and get it resolved as quickly as possible. And that otherwise, if we don't know about it, we can't address it. And then we're trying to encourage them to let us know. And the first step is through the elevator inspectors. And the next step will be with the elevator contractors and the owner or the owner's reps.
I'll start on this one. Many times, I'm sorry, I do a lot of litigation. And you find out that people involved in these accidents, and I won't just pick on Texas, though I do a lot of litigation in Texas. You don't find out for 3 years because that's when the limit of them suing occurs in that time period, a 3-year time period or something like that. Not a lawyer myself, but I do know that they're not ever reported. We are woefully inadequate in our communication. If you want elevator inspectors or elevator contractors to report this to you, you have got to put it in writing. You have got, right now, supposedly the owner is the caretaker of the equipment, and they have no idea what's happening in their buildings. A lot of them push that off to the management of the building. I guess the people that collect them rent. I'm not sure. But what I'm saying is we are woefully inadequate in telling all of these people or any of these people that they are required to report it. It's almost like, a child issue. Everybody is required to report that. A doctor, emergency room, a hospital, all of them are required to report it. And yet, I don't think I've ever had a case, except 2, of which Lawrence came out on one of them, and actually both of them, and boarded up the elevators. One was a death case, and the other was a farce. These people were trying to get money out of the hotel, basically. But I knew enough, and I also knew that he would come out and he would assist in the investigation initially, which was very, very helpful. We don't have that communication out there. Number 2, If they're telling an inspector and not notifying that inspector that there has been an incident or an accident, to go out and just do an annual test on an elevator, you are putting that inspector in a huge liability without giving them any information. And that, God help me, I'll say here, tell me if there's been an issue before you send me out there to inspect, because I'm bringing my own people, my own forensics, and advising them to bring theirs. It's more than the $100 you get for inspecting. I'll say that, because you're fixing to get caught up in legal issues. Anybody else? That was my rant for the day.
Ms. Sweat, Chris Funderburg, I just wanted to let you and the rest of the advisory board know that part of the communications issues that you're talking about have actually compliance is all too aware of these and the proposed amendments to the administrative rules that we've been working on. There is several substantive revisions that should help address these. Of course, we'll need the work groups and expertise in order to make sure that these are drafted as well as possible. But this is an issue that we're aware of, and we are working to resolve it as within the limits of our regulatory authority.
So, hi Sheila, it's Jerry Matheny again.
Jerry.
So I've had a conversation recently with Edmund and Delisa about the difference between an incident and an accident, which are extremely different. But I want to prepare you all for what's about to occur, okay? I don't think you have any idea how many incidents, not accidents, but incidents happen on a weekly basis. And I'm willing to bet outside a company I'm well aware of that I won't talk about tonight, but I'm willing to bet that the incidents that occur is at least 10% of the elevators and escalators in the state of Texas. And if you do the math, if everybody reported the incidents, Edmund, you'd get 200 a day. Are you prepared for that? And what in the world would you do? So be prepared for what you asked for. And incidents is something that's always occurred in the elevator business. And entrapment, I've never seen a jurisdiction use the word incident before. This is new to me. An accident is where something actually occurs to a person. Okay. Incident is where an elevator stops functioning. Is that accurate?
The incident normally does not involve any type of medical attention. The accident, when they call someone out to determine whether there's an injury, then I consider that an accident. The incidents can be simply the elevator stopped in mid-flight and they were stuck in the elevator and no one knows why. So that's why I want somebody to report this incident or this entrapment so I can follow up and have an inspector go out and look at the equipment and discuss with me prior to his inspection and then following up afterwards. If we don't know about any issues, then nothing is reported to us by the owner's rep, the elevator contractor, the management. There's not anything we can do about it unless we know about it. And like you said, there's quite a few incidents that have occurred that we're not aware of, but we're trying to reduce all these loopholes so we can force everyone to step up and report these incidents. And an entrapment would be an incident because we don't know why that elevator stopped.
Neither does an inspector, Edmund. Neither does an inspector. A lot of inspectors, just so we're clear, qualified for a license and never have worked on an elevator. Now, I'm not opposed to that. I didn't make the rule. But you send an inspector out to investigate an entrapment and he's never worked on an elevator, you're wasting your time. You have to send a qualified elevator technician to investigate this. And that's what we do. That's our job. That's what we're contracted to do. And I appreciate what you're trying to do here, but I think you ought to start at the violations. If you were just able to eliminate repeat violations, you're going to see a down drop in the incidents. I'm
And
just saying.
that's one of the things that we're doing now. We're holding the owner's rep accountable. They have 60 days to correct the repeat violations or have a signed proposal to correct the violation before the next elevator inspection, or they apply for a waiver or delay.
Well, here's
But
my recommendation, Edmund. You ready? Here's my recommendation. Not the first time you heard this, but if there's a repeat violation, you do not issue the permit. You do not issue the permit, and you demand from TDLR that repeat violation has been completed, and then you send the inspector back out there to make sure that it was done. Unless you want to license up the elevator technician and have them sign off on it. There's two ways to do it.
Someone has their hand raised, Mr. Funderburg.
Yeah, Chris Funderburg, real quick. The issue that you're discussing in terms of violations that continue to exist and aren't remedied this has been a hot topic for compliance, and they've been working with our licensing division steadily over the past 6 months to remove some impediments to taking, I guess, what you would call affirmative action against repeat offenders. And part of the 60-day requirement for proof of corrections is part of that process. So I only bring this up because that was the subject of one of our licensing work group. It is something that the department is aware of, and it is an issue that we're trying to resolve.
Good luck.
Yes, and
Thank you.
yeah, and I will say TDLR needs to hire inspectors willing, because they're going to get sued immediately if anything happened and they did not find it after the fact, especially if they did not know about it. So, I mean, budget wise, you're going to have to find someone that's a qualified, educated elevator engineer or consultant to work on that staff, that the state of Texas will cover their legal issues when.
I also want to talk about, Edmund, when you talked about an incident and you want to send out an elevator inspector to investigate that incident, who's going to pay for that inspection?
I contact the customer and let them know that I need to have an inspector go out, and they agree to pay for the inspection
Okay,
before
well, you
I
better get you a
contact.
whole bunch more Christopher Fundenbergs over there. That's all I can tell you right now, because you're dictating an inspection after an incident, which doesn't occur in ASME.
I don't know if anybody wants that, but.
Hello, Patrick Shaw here. Yeah, I'd like to talk about Mr. Funderburg. And also Edmund, on the actual inspection report. If you want to eliminate some of these overdue deficiencies that have happened, you need to try to take out of there that if they have a contract with an elevator contractor, they're just looking at it as, I don't have to change it for a whole nother year. I'm under contract. And so the things aren't getting done right away in your 60-day panel, the 60-day area, because it says in the fine print at the bottom, or if you have an existing elevator contractor under contract. So that's something to look at, and maybe one of our subgroups that we can go into. And I would like to say I'd be a part of any one of these groups on the side, because there's a lot of stuff that I think, Mr. Funderburg, you kind of glossed over in your group that kind of need to be addressed. with not so much on the law side, but more on the practical side of being in the elevator industry. Thank you.
Thank you.
Yeah. Also, I guess we can move on to this, because we don't really have very many inspectors here, but, all my inspections have, if I do an inspection and there's a repeat violation and there is a block marked that for that particular citation, repeat violation, to try really hard to bring it to the attention to people who are supposed to be watching this. So the next thing we have is the discussion of, discussion of rules and what is required by elevator owners. I will, before we get started on that, I don't have anybody to send it to. The owners have no idea. They only know to ride the elevator, barely. Anyone would like to address that? I'll open up the floor.
I can talk about this for a minute.
Go for it.
Elevator owners and facility operators depend on elevator contractors to get them through the maze of TDLR. And depending on who the contractor is, depends on how well that is conducted. And that's an unfortunate situation of the elevator industry in total. But the relationship between the owner, the elevator contractor, and TDLR is a severed relationship. There are not enough people in the elevator industry to conduct the amount of work that needs to be done. And Greg Tomas is on this call, and he's with the IUEC, and he will tell you point blank, there is not enough people in the industry to do the maintenance on 43,000 elevators, because I think Greg can tell us how many elevator technicians there are in the service industry, not in the industry, but in the service industry in the state of Texas. And all we have to do is sit back and do the math. And that's what's going to become the problem. It's getting worse and worse and worse. And the amount of units on a technician's route is unobtainable to perform maintenance. And if you do not perform maintenance in the elevator business, which, by the way, if anybody wants to talk about it, is public transportation, it's not being done. And nobody's enforcing it. And that's one of the problems that we have. I'll just tell you, I'm sorry, Christopher, but I'm going to give you a little bit of what I tried to do 14 years ago. And I saw the issue. I saw the issue coming for many years. And that's why I developed Ameritex Elevator Services, because I chose to change the life and the people who chose to do business with my company and do it with limited units on maintenance routes and address every emergency and repair. There's not enough technicians to do what I do. There's not.
Chris Funderburg, General Counsel, I agree. This is something that was brought up at the last Elevator Advisory Board meeting. It's something that the enforcement work group attempted to address. It is the disparity in ratio is troubling, to say the least.
Christopher, I just want to stop you.
Yeah.
No one's going to be able to change this because it's driven by economics by the elevator companies. That's the only people that can change it. Nobody on this call can make a change to it except for the elevator companies that choose to do it, but they won't do it because of economics. And that's wherein lies the problem. It's always about the money.
I guess, Chris Funderburg, a reasonable follow-up question would be, what is TDLR's role in this, if any?
There is no role. It's a relationship between the elevator companies and how they hire their workforce. And the elevator companies have decided that profit is above safety and maintenance and performance. Am I right, Sheila?
Yes, sir. Those of us in litigation appreciate people not maintaining the elevators.
I think, Chris Funner, General Counsel, during the enforcement work group, Edmund brought up that there's obviously far more money to be made as excuse me, I'll make sure I get the technical name right, technician rather than an inspector. The benefits are better, the pay is better. And so there's economic pressure to not be an inspector. I think that the possible solution that TDLR was looking at is, can we ease the transition from a technician to an inspector, and maybe increase the population that we can draw upon for licensees. But as I think, as Mr. Matheny was saying, our power to do something about this problem may be limited. But again, this is what work groups are for. And this is what a productive dialogue between experts in the field and the department are all about.
Chair, if I may interject, I apologize. I do need to step out, but I just wanted to say thank you for the input and the commentary today. And with regard to communications and engaging your advisory board with our development of the core application, as well as getting your input on the administrative rules, we will ensure to focus on the communication that you have raised as a concern throughout the meeting. And I just wanted to thank you all for your service and time today.
Thank you, Susanna. I appreciate it. I appreciate your input. I hope we can get it settled. Thank you so much. But this technician to inspector issue, number one, that's not ever going to happen. They do it when they retire occasionally, and they find out that it's not very profitable. I will also say it goes all the way up to AHJs. I've had multiple bajillion, or at least 25 places ask me to be an AHJ. And what they get paid is barely what my insurance costs me. So it is an impossibility, but we've got to try and try. And it still all comes down to money. You're not going to get qualified people in this industry, in the elevator industry, unless there's a lot of money. There's very few industries that hold people's safety in their hands, and the elevator industry is one of them.
Now, is there any way that Patrick Shaw, is there any way that we're able to come up with some kind of standard pricing that inspectors can make here, like a minimum at least? I know that, we're all
Not
for
third party,
private
not third
business.
party, not in third-party inspections. No, sir.
And
Yeah.
I just want to remind everyone, if you could identify yourself before you make a comment. I didn't do it right there, Chris Funderburg, General Counsel, but just as a reminder, yeah.
Yes. I apologize.
Sorry,
I'm
Christopher,
only-
Jerry Matheny, I'm not very good at this.
It's a process. I think, not to redirect, but I believe that, there's a host of issues that we want to address, right? And I think, I hate to sound like a broken record, the best way to do this is to take your expertise in your profession, meet with the department representatives, and hash these things out and find out where we have leverage and where we don't, what we can do, what we can't. And as I careful what you wish for, we're going to be seeing each other a lot within the next 2 to 3 quarters, just by nature of the rulemaking process. And so that means that these, not only will these work groups be meeting regularly, the reports will be generated regularly, then the board can take action on those, on the results of these reports. So I think at this point, we should probably, I've been making notes throughout the advisory board meeting as the primary issues of concern. Then I think what we should do is triage and maybe make 2, possibly 3 licensing groups, because it seems like most of these issues falls within the licensing category. Divide those up into the individual issues from there, assign members, and then get to work at that level.
I would just like to say one thing, Christopher. This is Jerry Matheny, Ameritex Elevator. TDLR is regulatory. The elevator companies are going to drive the change. They are the ones that drive the change. You guys regulate the change. And the sooner everybody figures this out, the better off we're all going to be. But how do you get them to change? That's the question that we have to have in these meetings. And I am willing at any time to show up in person or online and talk about this, because it's going to be something that you're going to find out happens throughout the country, not just in Texas, but throughout the country. And this is a big issue. And I don't think people are interested in talking about making it better. I think they're just talking about making it more profitable.
Chris Winter, General Counsel. The money, you follow the money. Yeah. And our ability to regulate the public sector is limited by our statutory authority, but we do have the blessing of the legislature to regulate this industry, and we have the administrative regulatory scheme in place. We'll meet and see what we can do.
So the next one is agenda items for the next board meeting. Has anybody got a list of what we've been talking about? This is Sheila Sweat.
Thank you, Ms. Sweat. I have what I suspect is a partial list. If you'd like me to go over
Please,
that.
could you read your partial list?
Partial list. So inadequate communication between the department and the members of the advisory board, safety issues generally. There's also a concern about the poor licensing database, but it sounds as though our executive branch, or sorry, our executive department is going to be, division is going to be addressing that. I think on my end, there's a standards of care rules work group. I would like to have any interested members of the advisory board please sign up for that, because the changes are substantial. We need your technical expertise, because I would like to get these going as soon as possible. Other issues that were being discussed are the lack of inspectors, also the building owners not knowing that they're required to reporting requirements generally, and let's see, the difficulty of elevator owners kind of driving some of the problems that we're seeing in this industry. I think I could go on, but I don't want to speak over anyone. That you may have more specific ideas that we could divide into these work groups. Oh, the building owners.
So,
yeah,
Christopher, it's Jerry Matheny again. I'm gonna tell you, in my opinion, and I hope everybody will listen to me. And it's not an opinion, but I've been part of this for a very, very, very long time. I'm not talking about this advisory board, but I can tell you the one difference that I've seen that makes a tremendous difference in all of the things that we've talked about was the licenses of technicians. And I could go into a whole dialogue about why that's important, but it puts people with personal responsibility for their work. Okay. Because you can get an electrician, he has a license in Texas. A lady that colors your hair has a license in Texas, but a guy that works on public transportation in a private building does not have a license. But yet he can work for a company. And I need to drive this, guys. I'm telling you right now, if I'm willing to do anything, this is the one thing I think will change the world in Texas. I work in several jurisdictions, and this is the only one that I work in, by the way, that doesn't have a requirement for licensing for technicians. The only one. So keep that in mind.
Chris Winterberg, General Counsel. Thank you, Mr. Matheny. My suspicion is that this would require a change at statutory level. So that requires the legislature being in town, which would be 2027. But that doesn't mean we can't, in the interim, maybe draft some bill language if we think it's possible that this is an area we want to explore, or at least look into the possibility of what would this regulatory scheme look like.
Well, I'm Jerry Matheny, Chris. Jerry Matheny, Ameritex Elevator. I'm not a politician, but I do know what this provides for the riding public, and it is substantial. And if it helps, I graduated from high school with Governor Abbott.
Then, uh, m- uh, sh- presiding officer, Ms. Sweat, did you want to create a educator, I guess, a licensing work group to investigate to start this dialogue?
Definitely, yes, definitely. It provides a stick that we don't have.
Okay.
I mean,
And so I would say, excuse me, Alex. Can we start with the work group assignments? It sounds like Ms. Sweat has some ideas.
of who to assign, I mean, I'm kind of like Jerry. I've been in this for well over 40 years and seen pretty much everything coming from here to yonder. And I would be willing to do anything that my expertise could help. I sit on many code committees. I have been the president of the Elevator and Escalator Safety Foundation. I've got many fingers in pots of all areas, and I can get people to give me information of their thought pattern also that would help Texas make their program better.
Chris Funderburk, General Counsel. It sounds like you may have volunteered yourself, but I also before we start choosing work group assignments, I just want to reemphasize the provisions of the Open Meeting Act and the dangers of walking quorum. Right? Any communications between board members have to stay within the work group that they're assigned. Communications outside of that work group, I strongly advise against it. But I just wanted to get that out there. So I'm sorry, Ms. Sweat, is there anyone else you wanted to pull for volunteering for this particular work group?
Also,
I will.
IUEC, who else feels strongly about it?
Okay, let
I
me
do,
jump.
Patrick Shaw.
This is Scott Anderson. I want to jump in. I think my actual title is I'm like representative of the public. And I don't know if any of y'all know my history with elevators and escalators. In 1994, my son's foot was amputated by an escalator. And
Precious.
I'm just going to say, you're saying, how do you change things? I filed a petition with Consumer Product Safety Commission. I went to trial, but more importantly, at the Consumer Product Safety Commission, we used the leverage from there to go into 17.1 and actually change the performance standards for escalators. And I was getting 2 or 3 calls a year on serious entrapments. And I'm here to tell you that on serious sidestep entrapments on escalators, I haven't had a contact in 8 to 10 years. I'd like to think it's the side brushes, but I'm just saying, you want to know how to change safety? I just did it as a father who felt honor bound to move the needle, and at least for that little part. So I don't have a lot of technical experience in elevators and escalators, but I do understand that part you're talking about the money and, moving the needle.
Sheila Sweat, and it's an honor to meet you, sir. I've heard about you and how we got brushes into Texas before. And thank you very much. You have saved many people's appendages and possibly lives. Okay. Anybody else want to volunteer?
Like I said, you tell me where I need to be. I'm not really sure where I need to be because I don't come with a lot of technical knowledge.
Well, we can
What did
assign.
Patrick Shaw here? What board is this we're talking about specifically? Or group? Sorry, groups.
Chris Funderburk, General Counsel. I thought this one was the licensing, that is, we're discussing the possibility of licensing elevator technicians in the state of Texas. And I'm not sure. It sounds like Mr. Anderson is maybe conceptualizing more of a generalized safety work group, but I would like to see if we can get a more specific topic, just so we're not spinning our wheels once work group actually meets.
Patrick Shaw, I'd like to be a part of the mechanics becoming certified in the state. Definitely, that is something that when I signed up to be a part of this advisory board that I mentioned in there, and it seems like we're going in the right direction, but maybe there's a couple more steps that we could take to even make it better. So thank you.
And Chris Funderburg, General Counsel, Mr. Anderson, and I wasn't trying to minimize, your willingness to participate. I just didn't know quite where to fit you into statutory drafting bills, right, for new license types. So, also,
Christopher, this is Jerry Matheny.
Yeah.
I have Greg Tomas on my screen here, and he is with the International Union of Elevator Constructors. Greg, how did, if you don't mind giving your elevator talk about how you guys stand on this
I'm sorry,
in the state of Texas?
is this a Chris Funderburg? Is this a board member?
He has his hand raised.
Oh, I'm sorry. Greg Tomas, he's not showing up. The video feed's not showing up on
Yeah,
my.
Greg Tomas is a board member.
Oh, okay. I apologize. He wasn't.
Mr. Thomas.
Oh,
Okay.
there we go. Appreciate it.
You're not, we can't hear you. You're muted.
I don't see him in here anymore.
Mr. Thomas, we can see you, but we can't hear you.
We're not hearing you, Greg. Just give me a thumbs up or down. There you go. There you go. So I want to be on this committee or club or whatever it's called, whatever you want to call it. And I think Greg will be on there as well. He's a member of the International Union of Elevator Constructors, Local 81 in San Antonio. I think that is very important. I think that is critical to the process of this because I'm not necessarily making a divide between union and non-union. That's not my purpose here because I know that non-union companies survive in Texas. But having the International Union behind this, I think is a good push. So I'd like Greg to be on there with myself. Sheila.
This is pretty close to the end of the agenda, so it might not ever be Sheila again, but I appreciate it. And that is, I think we should also send out some information about these committees and ask our board to volunteer for them. And then if they need their arm twisted, we'll find a good arm twister.
Chris Funderburg, General Counsel.
Jerry Matheny with Ameritex. That'd be Christopher. He's a good arm twister. I've seen him work.
Yeah, my pro wrestling experience finally pays off. But I just wanted to make sure of something, Chris Funderburg, General Counsel. Are we talking about establishing work groups and then assigning members once the board meeting concludes, or
can that be done?
Let me double check with Alex. Oh, yes, we can't do that. So apologize. Didn't mean to speak over you, Alex. Yeah.
Oh, no, it's all right. I was muted. So, but yes, we could do that. And then, like I said, this is for where we are now in the recommendations for agenda items for the next board meeting. But yes, we can't do that. We do have, we have a list from the last meeting if we wanted to go off that, or if we're looking to start a new list.
This is Sheila Sweat again, probably hear that last list because it's been a year since anybody's,
Okay.
I mean, we
I
brought up.
can send out the previous list, and then we can work off that to see if anything needs to change from that.
That sounds good.
Okay, so I will send that to all the board members for review.
Is my microphone working now?
Yes.
Yes.
Okay, all right. So this is Greg Temizia. I apologize for that, but I would definitely like to be on that licensing committee.
Thank you very much, Greg.
And the next thing is the discussion of date, time, and location of next board meeting.
Chris Funberg, General Counsel. I'd like to determine that at a later time because the work group rules committee, I would like to get a finalized version of the document in front of them, have them take a look at it, and then set the advisory board meeting date fairly close to that. So is that something we can determine offline, Alex, or?
Sheila, could we have a meeting and not invite Christopher?
It would not be the first. Yeah.
That is.
It's not personal, Christopher. It's not personal.
Alex Ortiz, TDLR, we can do that offline and then get that date once we have the information that we need for that.
Okay. And though I love Zoom meetings, when you stare eye to eye with people, you seem to get a lot more done. So, is there anything else anyone would like to say? Because the next thing is adjourning, and we get to have somebody saying yes, adjourn, and somebody approving the adjournment.
At this point, we would not need a motion or a vote
Oh,
for
good.
adjournment. You can just call it when you'd like.
Okay, anybody else want to say anything? Let's go eat lunch, folks. This meeting is adjourned.
So
Oh,
Dinner. Sheila.
dinner. Oh, that's true. In Italy. God help, I wish I was there. Talk to you later. Bye, guys.